very good evening and a warm welcome to Personal Finance. I'm Kukuletu Cele. Now, marriage can be a tricky subject when it comes to your finances. And when it's not civil and the relationship runs its course, bigger issues can arise than who gets to keep the dog. Jack Cooper from Cooper Attorneys and Nick Dekker, Certified Financial Planner from Ultima Financial Planners, joins me now for a look at the legal and financial implications of common law and customary marriage. Gentlemen, good to have you with us this evening. Maybe let's get into the definitions first and the nitty-gritties thereof. And I take it you're the good person to start off with here, Jack, with the legal implications. The definition of customary law or customary marriage, how does it differ from a civil marriage?
Okay, but prior to 1998, African customary marriages and polygamous marriages were recognized by common law. But in 1998, they brought in the recognition of Customary Marriages Act, and that formalized the recognition of both customary and polygamous marriages. And it also gave legal status to women in a marriage. The conditions were that you had to consent to the marriage, you had to be over 18, and you had to notify the Department of Home Affairs within 3 months.
Is that where the trick comes in, the notification to Home Affairs within 3 months? Because some people leave it for a lot longer and then time lapses, as you say.
Well, if the marriages hadn't been registered before 1998, they gave them a year to register all those marriages. But after 1998, the provision is they must be registered within 3 months. I suppose if there was a hitch, they would still register it, but that's the formality.
Now, what's unfortunate here is that all of this does have some kind of financial implications on one's financial planning, I take it. And clearly there's certain considerations to take into account, because with a civil marriage, we know that you can have an antenuptial contract, whether that's with accrual or without accrual. But when it comes to customary marriages, is there a certain guideline as to how to manage your finances there?
Again, if you look at the definition of spouse, there are various different definitions regarding which act you have a look at. There's the Estate Duty Act and the Pension Funds Act, which I think about, and all of them had different variations of a definition of spouse. Whereas Jack and I had the discussion earlier, most of those definitions nowadays are more or less streamlined and also take into account the common law aspects as well as same-sex marriages. The problem is, if it's not formalized in a contract, you may have a problem, because then you have a problem to a burden of proof for a person. That if you think that something is rightfully yours, a right is something that you can sue for, then you have to prove that specific right. For instance, if you look at the Medical Schemes Act, it allows for, it doesn't so much talk about spouse, but more about a dependent. So as soon as you bring in someone under your medical aid as a dependent, it may have implications if you look at the Pension Funds Act, which will include retirement annuities and that.
I want us to get into that in a moment or two, but the proof that you alluded to, how do you deal with this? Is this an ordinary piece of paper where there was an agreement here, Jack, that a certain amount of lobola was paid and accepted, hence now there is this union between these two individuals, or even a representation from a religious leader when it comes to Islamic marriages? Would that count as the proof necessary?
Well, if I can just finish off what I was saying about the Recognition Act. It also provided that women have the same status as men, the same legal status. They can contract on their own, they can own property, etc. Previously, a woman was under the marital power of the husband. And now they've both got the same power. And if there's no contract or agreement that you can show, then the marriage is deemed to be in community of property. So it's recommended that anybody who enters into a normal marriage or a customary marriage take out an antenuptial contract so that the proper rights of property ownership and assets can be discussed and added in and allocated as to how they want it. So it's very important to enter into this contract before you get married, and then register the contract, so that if anything happens, if the marriage dissolves, then here you've got a piece of paper to prove ownership and division of property, etc.
I want us to touch on that just for a moment or two, just to get into that further. If you want to switch, maybe you married customarily and you weren't aware of the legal implications that now this is in community or property. Should they want to change later on within their marriage, is that still viable? I know it's a lot more expensive.
You can apply to the High Court to register a post-nuptial contract, setting out the same terms and conditions as if you entered into it before you were married. This does happen on occasion, and the courts normally consent to registering the contract, which is registered at the deeds office.
And would this apply from the date of registration and all other assets acquired before that?
It would be retrospective to the time that they were married. Unless there were huge variations in the property regime. For example, if a house had already been sold and they wanted to change it, well, then they would have to enter into a contract to compensate for that.
Sure, which means a lot more paperwork and a lot more stress.
A lot more expense.
Exactly.
Yes,
Let's come to the financial planning part, and let's pick up on the medical aid that you alluded to here, Nick. So you have this customary marriage that you engaged in. You can include your partner in the medical aid, or will certain medical aids view it differently depending on the terminology used?
Yeah, so again, normally with a medical aid application, when you want to add someone as a dependent, you have to declare why that person is in fact a dependent. So it's easy. If it's a spouse, legally married, it's easy. If it's a child, a natural child of yours, it's accepted, and also adopted, legally adopted children. The problem is, I foresee, is we have the polygamous marriages, which we also want to discuss, is to have that proof, and it's basically it's a declaration, it's an opinion. But once that person can prove that he or she is a dependent of that main member, I mean, there is a dependence relationship.
How do you prove that, though? Does that mean that I earn less money than him, so hence I'm more dependent on him, or I'm completely unemployed and have no financial independence?
No, it may not be solely dependent on one salary. I mean, it's a cohabitation. So one brings something to the relationship, and the other party may bring something else. So it's not necessarily only financial, but I mean, it's a declaration that you make. You say this person is a dependent of mine, but that may have further consequences at death, or let's say at separation.
Sure, we'll get into that. I think that's where the juicy part starts in this particular topic. But also when it comes to your retirement annuities or provident funds at work, can you also include these individuals as your dependents in your contract?
Yes, interesting with the Pension Funds Act makes provision. You can, for instance, nominate a beneficiary on your pension fund or retirement annuity, but the trustees have an obligation to pay the proceeds upon your death to your dependents. And there's a specific definition of dependent, which will include spouse, but also people who are in fact dependent. For instance, if I am married and I get a scallopy on the side, and I decide, no, I'd rather leave my scallopy the money, the trustees have a burden on them to make sure that the proceeds pay to the dependents. So even though I nominated the scallopy, they may award the benefits to my wife and children.
Would those be the people then who might decide whether or not to give the money to your scallopy?
The trustees, yes. Yeah. If she was dependent, she also may have a claim. But first they have to look at dependency before they can use your the benefit nomination form as a guidance. But they first have to determine the real dependence.
I can tell you a lot of wives might be happy about that particular clause being put in there.
But I mean, it's there for safekeeping.
Exactly.
Yeah.
And Jack, maybe that brings us back to the polygamous topic, because then who gets recognized first? Is it the first wife, or is it the third wife?
Act, the husband can take on another wife, but then he's got to register an agreement making provision for the first wife, or the second wife, or the third wife, and so on. So every time he takes in another wife, he's got to make an agreement, draw up an agreement to make provision for the wives in succession.
Does that mean that basically the state will recognize them all equally and not necessarily give preference to whoever came first?
I think they would probably be recognized in terms of the agreement that is provided. But if the agreements are in contradiction, I suppose all wives would be recognized equally, which would only be fair.
Let's get to that issue then of death, because especially in a polygamous arrangement, maybe one is married customarily and another engagement is reached, maybe if in a civil matter and it's recognized by law. There again, are there certain nitty-gritties, or will the state completely rely on a last will and testament that might have been left by the individual, by the deceased?
Well, the last will and testament will be primary in dividing or distributing the assets, but there would have to be provision for maintaining each of the wives in succession. In other words, if the husband dies, then there would have to be provision for each of the wives. They could claim from the estate for maintenance. It's a very complicated situation, and that's why they want the husband to make provision in this agreement to look after the wife as he takes on other wives.
The proof would need to be there.
Yes.
Nick, I'm sure this is then certainly why, as a financial planner, if you could give out advice to someone who is in a polygamous engagement, then clearly having a clear set out rule of engagement with these individuals is something that's key.
No, absolutely. And that's why from our side, one of the most important questions when someone sits around the table for financial planning is the discussion around how you are married, because it may have dear complications and not while it's not while the relationship is running smoothly. It's when the relationship ends, and it can only end at divorce, if you're not married, separation, or death. And then, especially at death, that person, the estate planner, is not there to present his case. That's where the importance of a will comes into play.
Let's talk about debt, because so often we hear about that, and yes, there are protective measures that you can put in place here with an antenuptial agreement, but when it comes to customary marriages, automatically, will his debt be my debt and vice versa?
Well, if there is no agreement, the marriage will be in community of property, and so there'll be a joint estate, and if there are claims against the estate, it'll come off the joint estate.
Sure.
And whatever is left over, the wife or the children will get. But if there is an antenuptial contract, that can protect assets that you brought in before you were married. For example, if you owned a house, or motor vehicles, or jewelry, and the most popular antenuptial contract is with the accrual system, where you list all your assets, and then the assets are valued, and then the accrual will be pro rata to these assets. And in the end, whatever is deducted from the common gain from both, during the marriage, will then be the amount that will be used either to pay out the spouses. This is in a divorce situation.
Exactly.
Or to pay the creditors of the estate.
So it can get quite messy. Unfortunately, we have run out of time, but I think this is definitely a topic that we can follow through with again. So things to remember is that this is recognized, but you need to register it within 3 months of getting married. You also need to have the proof, the necessary documentation to show that you have both agreed to get into this kind of engagement, and most importantly, have a plan. Speak to a financial planner as to what happens with regard to your financial planning and your guidelines as a couple.
Absolutely.
And I think if you don't have a contract, then it'll be regarded as in community of property.
Exactly,
yeah.
Which comes with its own risks and rewards, certainly. Gentlemen, thank you so much for joining us. It's been an insightful conversation. Wish we had more time.
Been a pleasure.
But that is it for Personal Finance this evening. Thank you once more to Jack Cooper from Cooper Attorneys and Nick Dekker from Ultima Financial Planners. Remember that we'd love to hear from you, so get tweeting or send us your comments to @CNBC Africa using the hashtag Finance410, or even to myself @Kukumfupi. Until next time, it's goodbye for now.